Hi, it's Mike DelSignore here. I want to talk to you today about what happens if you're arrested for OUI and you're arrested by the North Attleboro Police Department. So your case, if you're arrested by the North Attleboro Police Department, will be heard in the Attleboro District Court. I have an office right next to the court at 120 North Maine Street, Suite 306. I've been in Attleboro for years, so I really know the ins and outs of that court, and I've cross-examined North Attleboro officers countless times, so I probably even had cases with the officer that arrested you in particular. So North Attleboro does have a video of the booking process. It's not a good quality video, but it's something. So you want to make sure we do a motion to preserve to keep that video. It'll show you basically walking down a corridor, and it shows you near the breath test machine. So if there's a breath test case, it's helpful because it can show any breaks or gaps in the observation period. So here are some of the key mistakes people make when charged with OUI. They assume they can't win the case because of the breath test. They quickly resolve the case without understanding the legal defenses and make decisions without understanding really what the police report says and what it doesn't say. And let me talk about that first, the police report. And I don't want to make it seem like the reading a police report is some big mystery or it's difficult or only I can do it as an attorney, but there are some things that I can explain to you that you're probably not going to pick up just reading these things the first time. First of all, when you read a police report, they don't put all the things that you did correct. So if you've never read an OUI report, if you're not familiar with the officer's training, how they're trained, you're going to miss all of the good things because that's not going to be in the report. So for example, I looked at a police report with a client of mine. She was a middle-aged woman, middle-aged teacher, and what we did was when we went through the report, I showed her all the things that she did right. Essentially, that when she got out of the car, the report didn't mention that there was any difficulty with balance. So I said, this is something you did right. When I get the person on the stand, they're going to say you got out of the car, you didn't lean out, use it for balance. So the fact that there's nothing in the report about how you got out of the car, that's one indicator that you weren't under the influence. Now, we're not going to win the case on that alone, but we're going to combine all these and then argue that in totality, she did far too many things right than wrong, and that when you look at this case, the signs are inconsistent with somebody under the influence of alcohol. How you provide the license and registration. Typically, if you do that correctly, there's no mention of it. Person provide the license registration, it's in the report. So what they're looking for is people who fumble, bobble it, have difficulty retrieving it. They go by the license once. So when there's no mention of that in the report, that means another sign that you handed it to the officer. You didn't have any issues with dexterity. You responded promptly. So another little building block. So these things, and that you don't have to have all of them, and very few people are going to have all of them. There's going to be some indicators. But those are some of the things that you're not going to see in the report. If you see moderate odor of alcohol, that's good for you. There's always going to be an odor. Moderate, a lot of times the reports say strong, overwhelming. So you got a moderate odor, we're going to argue that's inconsistent with somebody that's too much to drink. That's casual drinking, social drinking. It's not illegal to consume alcohol and drive. When you get to the field sobriety exercises, again, you're not going to see the things you did right. You might have in your report that walked out 9 steps, missed heel to toe, is unsteady. Well, first of all, the officer doesn't specify how many steps you missed heel to toe. So there's 18 steps. By the time the case goes to trial, the officer's not going to remember, and you're going to get, and I don't know how many steps. Any I don't know answers are good answers for you, because that's not beyond a reasonable doubt. That's not somebody sure, convinced of your guilt and of his opinion. So if it's just you missed heel to toe, you were unsteady, that means you walked out the correct number of steps, you looked at your feet, you didn't stop while walking, and you stayed balanced during the instruction stance. So they don't put in the report things you did right. So they will never say in the report that, I was looking for 8 different things. I noticed 4 things, but they did the other 4 things right. So those things are all sort of silent in the report. And what we can do is, just because they say you did something wrong doesn't mean you actually did. There's standards for this. There's a training manual. I have the training manuals in my office, and there's the specifications. So if they say you use your arms for balance, it's really not a problem unless they're 6 inches from your body. If you missed heel to toe, you're allowed a leeway, so you can have a 1/2 inch space. A lot of officers don't even put that in the report. A lot of them don't even remember that from their training. When I confront officers with their manual, a lot of times they say they don't recall that. And then I show them the manual and they say, oh, okay. So what happens is people look at these reports and they think they're bad when they're not as bad. Usually the reports are always going to have negative details, but you got to understand, is this report, how is this going to play out at trial? Will you be convicted? And then you really need to know, one, who might hear the case, the jury pool, and when you put it all in context, you'll have a more accurate view of what you should do with the case. And that's where I can help you do that. It's not something you can do on your own. Comes from years of experience, cross-examine officers, and there's different tricks and techniques that I've learned that can really help paint a picture of you of not appearing under the influence of alcohol. What else do I see? I see people that quickly assume they can't win the case because there's a breath test. A breath test evidence doesn't always come into evidence. It's not always accurate and reliable. So don't assume that if you took a breathalyzer, that one, that's going to be heard in court, and two, that it's accurate. And finally, people assume that, well, it's no big deal if you accept a continuance without a finding. They hear that term in court, but that is an admission to OUI, and in many cases, you're not going to be much worse off if you had taken the case to trial. So if you remember these three things, feel free to contact me. My passion is helping people understand and make the best decision they can when they're charged with OUI. I've been doing this for years. Attleboro's been a court I've been going to since I started my career way back in 2001. So I'll be glad to help you. You can call, text me. I look at police reports all the time. And I look at them, and there's no obligation to even hire me. I'll be glad to give you my opinion on the report and let you know how I think the case would play out and what you should do. Ultimately, it's always your choice as to how you're going to handle the case. But I'm here to help you if you need it. 781-686-5924. Michael DelSignore. It's never too early, too late to call.